Welcome to Estate Planning with Bernard Law.
Hello and welcome to Estate Planning with Bernard Law. My name is Kevin Rosenquist and I am joined by Daniel Bernard, whose practice focuses on estate planning, wills and trusts, probate avoidance, and asset protection for clients in both New York and Florida. Today we're going to talk about what happens when you die without a full estate plan and why a will isn't enough. Daniel, welcome. Great to see you.
Great to be here. Thanks for having me.
Yeah, absolutely. Estate planning is one of those things that we all know we need to do. Not everybody does it when they're supposed to or at all, and that can cause problems. So let's start with that exact statement. The problems. What actually does happen if someone dies with either only a will and not a good plan around it, or no plan at all?
Absolutely. So in New York and in Florida, both states have an estate plan already designed for you. It's just the statutory estate plan. If you die without a will, it's called dying intestate. You died without a will, and you're subject to what New York State or Florida has in store for you. And that may be what you want to do. It may not be what you want to do. That estate plan might be exactly what you want. It might be the exact person that you want to manage your estate may step up and decide to manage that estate, but it may not be exactly what you want. And it certainly is going to be time consuming. So whether we have a will or we don't have a will, our estate is going to be subject to probate or administration within that surrogate's court or probate court in the county where we pass away. And what that means is if you've ever been to the DMV, it's essentially you're at the DMV, but you're there for 9 months and waiting for someone, waiting to be appointed as executor, waiting to be appointed as administrator. And this process, as you can imagine, is time consuming and it can be quite expensive because typically people have to hire attorneys to help them through that court process.
Yeah, you should just lead with the DMV analogy, and I think everybody would run out and get an estate plan immediately.
I was at the DMV 2 Fridays ago for the Real ID, so I'm with
you. The Real ID, yeah, that's another one. Okay, all right. Well, how much control does the state have over who gets your assets? I know you mentioned that it might be what you want for your plan, but probably not, right? And how much control do they really have?
Sure. So the important factor is the state only has control over what are called your probate type assets. So when you pass away, your assets are divided into 2 categories: probate assets, non-probate assets. Probate assets are the ones that the state has control over a little bit because you need to be appointed as executor, or you need to be appointed as administrator. You need some document, or your executor rather needs some document from the court in order to transfer that asset. That begs the question, what's probate assets? What are non-probate assets, right?
That was going to be my next question. So you're good at this.
Probate assets. I've only done about 1,000 of these presentations and that's always the next question, right? What's probate? What's non-probate? Non-probate is easy. It's anything that has a beneficiary designated. That can be your IRAs, 401ks, life insurance. Even your house, if you own that jointly with your spouse, is non-probate because that's jointly owned. Probate assets are everything else. Anything that does not have a beneficiary. So if you own your house by yourself, that's going to be a probate asset. So typically I say the house because for most of us, that's our only probate asset is our house because we don't have a beneficiary on there. And if you own a business, then your business would be a probate asset as well. LLCs, corporations, things that we just could not designate a beneficiary for are the probate assets. And that's where the state's going to have that control over you because you can't pass that without going through that court system.
And you mentioned dying intestate. What's the difference as far as having a full estate plan? Like, how does the process unfold, so to speak?
Sure. So if you die intestate, that's dying without a will. That means that someone has to step up and decide to petition the court to be the administrator of your estate. That is usually, if you have a spouse, that's probably going to be your spouse. If you don't have a spouse, that's probably your kids. If you don't have kids, that's probably siblings. And they have to petition the court to be your administrator. They have to give notice to all of the other beneficiaries. So if it's one of your kids, they have to give notice to all the other kids. It's one of your siblings, they have to give notice to all the other siblings. They have to give notice to anyone that would be next in line to inherit. And that's basically what intestacy is New York State, Florida has decided who's next in line to inherit your assets when you pass away. And that might be the people you want to inherit them. It might be the people you don't want to inherit them.
Okay. What have you found over your career that are the biggest misunderstandings or myths that you hear people have about wills, about probate, or estate planning in general?
Number one is a will is enough. If I have a will, I'm good to go. That's just not the case anymore because our courts are just so backed up, so clogged with cases that it's just taking so long to get through that court process that maybe 20 years ago, a will was enough and that distinguished you between the administration and the probate people, and the probate would move a little bit faster. Nowadays, we're just too backed up and the probates just take way, way, way too long. Like I said, 6-7 months before someone's appointed as an executor, and that's if you have everything lined up and everything is easy for the court. So that's one of the biggest misconceptions. I have a will, I'm good to go. And then the other misconception is I have a will, I don't have to go to court. Why would I have to go to court? I have a will, and the will has to go through that court process. The document that doesn't have to go through court is a trust. If you have a trust, you don't have to deal with court as long as you have those probate assets in the trust. So a lot of times people tell me I have a will, that's enough. The will doesn't have to go through court. And then the other one is I get on the administration side is, I'm named as the executor in the will. I'm the executor. Only the surrogate in the county where that person died can appoint someone as executor. Being named an executor in the will does not make you the executor. That makes you the nominated executor.
Okay. So let's talk about this then. You brought up trusts, which I'm interested to talk about. But in addition to that, you say a will is not enough. Tell me what I need.
Sure. So in the context of avoiding the probate process, keeping your kids out of court, making sure your kids don't have to do that 9 months at the DMV, what you need is a trust. And the difference between a will and a trust, quite simply, is a will goes through the surrogate's court process. A trust does not go through the surrogate's court process. So a trust typically is going to have a lot of the same terms that you would see in a will. A lot of times we think of it as a modern version of a will. The trust is going to tell us what happens to all of your stuff when you pass away. The trust can even tell us what happens to your stuff while you're alive. And probably beyond the scope of this podcast today, but your trust can be revocable or it can be irrevocable. When we dig into that trust planning, revocable is really just about replacing your will. Whereas an irrevocable trust, we can do some planning for long-term care, or we can do some planning to avoid estate taxes, depending on your situation, as far as if you need that long-term care planning or you need that estate tax planning. But trusts allow us to do that kind of planning in addition to avoiding probate.
Okay. So what else in addition to a trust do you recommend for people?
Oh, absolutely. And then our wills and our trusts really only control what happens to our stuff when we pass away, right? And I said the trust can tell us what happens to our stuff while we're alive, maybe if we become disabled or incapacitated in some way. But there also can be a period of time before you pass away where you need someone to make a medical decision for you, someone to manage finances for you. So that's where I have all my clients on a healthcare proxy. That's someone to make medical decisions if they cannot make their own medical decisions. I have them sign a power of attorney. That's someone to manage their finances if they can no longer manage their own finances. And as you said at the top of the program, I do a lot of work in New York and Florida for snowbirds. So my snowbirds, we put those in place for both states, which is incredibly important because if you don't have these documents, what happens is your family has to do a guardianship proceeding for you. Guardianship is they're taking you to court. They have to take you into court, tell the judge that you're incapacitated, prove to the judge you're incapacitated. tell the judge that they want to be your guardian, essentially, and then the court will appoint them if they can prove that you're incapacitated. The problem with that is, first of all, it's embarrassing, right? You have to be brought into court.
Yeah.
Second, it's expensive. You have to hire attorneys. You have to hire doctors to say you're incapacitated. It's time consuming. Nothing in the court goes quickly. And it might not be the person you picked that steps up. If you do a healthcare proxy, you do a power of attorney, the person you're picking is making those decisions for you rather than the person that the court picked or that decided to step up.
Okay. All right. Interesting. And what do you find surprises families the most when a loved one passes away without planning?
Oh, so this happens all the time in estate administration. Inevitably, we get 3, 4, 5, 6 months into it, and they say to me, Dan, this is such a hassle. Is there anything my parents could have done to avoid this process?
You're like, yes.
So I tell people all the time, my best estate planning clients are the ones who have gone through a probate with mom or dad, because they really understand how much of a pain in the neck probate is and why the trust-based planning is so important. And then on the flip side, I get the people that come in, their kids, they did do the planning, and their kids don't believe me how easy everything is. And they're like, no, Dan, my friend went through this. It was much more difficult. And I tell them, no, your friend's mom or dad did not do the planning. Your parents did the planning. They took care of theirs for you ahead of time. It really is this simple.
Wow. That's the good one. That's the good surprise.
Those are the ones that's hard to convince to do estate planning. No, estate planning is easy. No, it's easy because we did the planning ahead of time, right?
Right. And does having joint accounts or beneficiary designations, that doesn't just protect you from probate, right?
So beneficiary designations are great, and they can avoid probate a lot of the time. But the problem is always, if you don't have, when you get to the end of the line, if you don't have a beneficiary on an account, you can take an account that was non-probate and now it's a probate asset, because if you don't have a beneficiary, now it's part of your estate. So whenever you're updating your estate planning documents, I always encourage people, make sure your beneficiaries are up to date. Make sure you have a contingent beneficiary. If something happens to your spouse, make sure your kids are on there and are going to collect that account. And that's why a trust can also be a great vehicle, because your trust can be a beneficiary on a lot of those accounts, and you can use that trust to protect the assets for your kids. So you can protect the probate and the non-probate stuff with trusts.
So this is our first episode of our podcast. I'm curious, what led you to estate planning and things, stuff like that?
So I started out my career in matrimonial law, and in divorce, there's really there's no winning. At the end of the day, you have less of whatever you had before. You have less money, less time with your kids. It's everything is less. I tell my clients all the time, you don't need an attorney, you need a hitman for the settlement you're looking for. Because everyone wants, I want all the money, all the time with the kids. It's just not possible, right? So I love about estate planning is I really feel like I'm helping people. When I did divorce, no matter how good of a job I did, at the end of the day, people had less. In the context of estate planning, I'm providing real relief for people. When my clients leave my office, they're happy that they knocked something off the to-do list. They're happy that they're doing something for their family. They feel like they're taking care of their kids. They're making sure the government gets a little bit less money. Nothing wrong with that. Mm-hmm. And they, in general, clients, you can provide some real peace of mind for people, and you can really help people through a difficult time. And that's what I really like about estate planning.
What do you think the main reason or reasons are for why people tend to keep kicking that can down the road and not setting up their plan? Why do people, we all know we should do it. Why are people resistant?
Sure. That's always the tough part. I tell people all the time, no one likes to come into my office and talk about their death, right? You come into my office, I say, hey, let's talk about when you die. Now let's talk about when your spouse dies. Now let's talk about when what happens if your kids die before you? Who do you want to raise your children if you couldn't raise your children? I ask a lot of questions that people don't really want answer, right?
Yeah.
But we talk about, hey, let's set up a trust for your kids. What if your kids become gambling addicts or really bad things happen to your kids? They marry an awful person. How do we protect against that? But at the end of the day, bad stuff can happen. So I think it's better to be prepared for that bad stuff, number one. And number two, I tell people all the time, when you do your estate plan, it's like you buy a snowblower. When you buy a snowblower, it doesn't snow that winter. Do your estate plan, you live forever. I'm still scarred from my parents got me that sled for Christmas when I was 12. I don't think it snowed until I was 15. I think my kids use that sled more than I got to use it. So I tell people, do your estate plan, you'll live forever.
What advice do you have for anybody listening who knows they need to start but haven't taken that first step yet?
My advice would be schedule an appointment with an estate planning attorney and sit down for a consultation, hear what they have to say, learn about your options. One of my favorite things about this job is that I look at myself as putting information out into the community. No one's teaching you this in high school. It's like a lot of time, when February 15th comes around, everyone complains, why did I learn to square dance? I didn't learn to do my taxes in high school, right? This is the same concept. No, I tell people all the time, no one told you about probate. No one told you about setting up an estate plan. This is a new endeavor. It's a lot of different information, and no one should be expected to know this stuff. So make an appointment with that estate planner. They can fill you in on what you need, what's going to be best for you. They can perhaps fill you in on what's going to be best for your parents and help you in that regard. Because it's not just always about us. We're going to have to a lot of times do this for our parents or the aunt and uncle, that the confirmed bachelor uncles. And so it's always, I think, take that first step, make that appointment. You typically, if you come to me, I'm not going to charge you anything. I just love to hear myself talk and answer all your questions. So just come on down and let's see what you need.
Why did we have to take square dancing in school?
I think it was just to torture us.
That really did not make it. What a waste of time.
I was sick on square dancing day, so I still can't square dance.
I don't even really remember. I remember do-si-do, and that was about it.
It's square dancing and the playing that the recorder.
Right? Yes, that was a nice sounding instrument. Okay, well, I digress. We won't go into that. All right. Well, thank you very much for joining us today on Estate Planning with Bernard Law. To connect with Daniel or learn more about protecting your family's future, visit BernardEstatePlan.com. And don't forget to subscribe to our channel. We got lots more great information coming your way. Daniel, great having you on here. Excited for future episodes.
Absolutely. Me as well.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.